should be reversed. As a preliminary matter, there are 5 issues that we've raised in our briefing. For today's purposes, we will focus on 2 of those. The first being right to counsel of choice, the second being Mr. Frazier's sentencing. So by way of background, this court has already seen the facts of Mr. Frazier's case. This was originally charged in July of 2012. Mr. Frazier was initially charged with first-degree murder. He first proceeded to trial in January of 2016. He was convicted as charged of first-degree murder. That conviction was appealed to this court, and ultimately this court on July the 1st of 2019 reversed the conviction, remanded it for a new trial. And so at that point, Mr. Frazier had been in custody, either in local custody or in TDOC for about 7 years. There was a new trial date that was scheduled once he was remanded for April of 2020. Due to COVID, that trial date was canceled. He filed a pro se motion to reduce his bond that was granted by the trial court. And so on May 26th of 2020, he was released for the first time since his arrest in July of 2012. And so the record, what we tried to lay out is that once he was released, Mr. Frazier had multiple conditions. Those included a GPS monitor, those included pretrial supervision, both of which had fees associated. He had a very large money bond that the court had set that he needed to post. And so there are multiple orders that the trial court had filed, permitting travel, permitting to try and make this doable so that Mr. Frazier could work, could earn money, could support his family, and try for the first time since the inception of this case to litigate the facts that he was charged with. And so in April of 2021, before this retrial, he was able to hire a firm, Logan and Thompson, out of Cleveland, Tennessee, to represent him. He made those financial arrangements. Mr. Thompson appeared, Mr. Logan appeared with Mr. Hewitt via Microsoft Teams and asked Judge Green to continue the trial. They didn't ask for a year, they didn't ask for 9 months. They said, we can get this ready in 3 to 6 months. And this was a situation where we are on retrial, and I think in terms of a right to counsel of choice analysis, that is really significant. This was not a new case. This was something that had been litigated. Every single witness that testified at the first trial testified at the second trial. The state sort of makes mention that they had to go out and round up witnesses, and that I'm sure is true, but all of these folks had already been cross-examined. And so when Mr. Frazier came to the court and said, look, I have lived with this case since 2012. These folks are the ones that I have saved my money, I have hired, I am confident in their ability to represent me. The trial court denied that by basically saying, you can show up in 2 weeks and try a murder case, or we are not moving this trial date. We are putting our foot down and you are going to trial.
Let me ask you a question. When a judge is considering whether or not to reset the case, like in this particular case, the fact that the case has already been tried and the fact that all the parties have the transcript because it was on appeal, does that not essentially help a defense lawyer to already know what the case is about and what the state's witnesses are going to say, and as a result probably doesn't have the same need to go out necessarily and investigate witnesses and other things that they might have if it hadn't been previously tried?
That's interesting. I think sort of. The other thing I'll clarify for the record is we are here on a delayed direct appeal because trial counsel did not file a motion for new trial, and so one of the claims that has been stated is a failure to investigate. And so I think that there were certainly witnesses that were that were part of the facts of this case that were never spoken to, and so I think it was fair for a new lawyer who was representing Mr. Frazier to look at the proof that came in at the first trial, see what the deficiencies were. There was a lot of discussion about the different folks that were at the scene of this shooting. There was a large fight that was happening when Mr. Frazier arrived, and so the relationship between those folks is something that is just not, it's sort of assumed. The lead investigator makes his determinations of how he believes all of these folks are connected. That's their assumption. There's really not any substantial facts that support that in the record. So certainly you would have had a substantial lead as trial counsel for a retrial to have a transcript of what everyone said, but I think you would have still had an opportunity to at least make sure you went back down the list and went back through the discovery and didn't miss anything.
Counsel, I'm interested in whether there are limits on the right to have retained counsel come into the case. Explore with me, maybe just for a little bit, some hypotheticals. Let's assume that defendant is indicted for second-degree murder, has appointed counsel. Appointed counsel is ready to try the case. The jury is picked, the jury is sworn. On the third day of trial, defendant comes in and says, I have hired new counsel. I wish to have appointed counsel discharged and new counsel come in. could the trial court in that case properly deny the defendant his right to represented counsel?
I think so, because jeopardy has attached at that point, and I think that we use that as sort of a line in the sand on lots of other issues in terms of mistrials and things like
Okay.
that, and so.
Let me back up the timeline
Sure.
slightly. Same facts, but before the jury is sworn, but after the jury is picked. Defendant says, I'd like to have my retained counsel come in. Could the trial court at that point deny retained counsel?
I think it depends, and I think it depends on whether the defendant had made clear to the court before the trial had started, this is the person that I have requested to be here with me through trial. And I think in the United States Supreme Court case we cite Gonzalez-Lopez, that was a lot of the discussion is I have brought this person in, the court is aware of this person.
Right. Okay, so in my hypothetical, let's assume that defendant did not make the trial court aware.
Sure.
We would agree the trial court probably has discretion to deny retained counsel at that point.
Absolutely, yes.
Okay, all right. It strikes me that if we agree, at least in those situations, that you have the trial court due to scheduling concerns, questions of the docket, the ability of the parties to prove a case, that at least on an extreme case, there may be reasons we can deny it. What we have here is a case that is 9 years old. We have a case where the defendant's been out on bond for some time. We have 2 or 3 weeks prior to trial beginning anew, I think for the first time, entry and announcement of counsel of Mr. Logan coming in, maybe for the very first time, 3 weeks to go, and a representation by Mr. Logan. And look, we all know Mr. Logan, good choice of counsel in my view. But at the same time, Mr. Logan's coming in saying, I can't meet your schedule, Judge. You're going to have to continue the trial. And the argument here is that as a matter of law, the trial court's decision not to continue the trial violates the right to retained counsel.
I think that's right. And obviously,
Why is that?
we're in a very different boat because this is a retained attorney situation. We're not, if Mr. Frazier showed up and said, I am now dissatisfied with my second appointed attorney, I think the court is going to have a very different inquiry because that is a right under Gideon to have someone there with you. You're not entitled to someone you like, someone that's your best friend, but you have the right to have competent counsel. When you are going out and hiring an attorney and that is who you have picked, you are not asking the court to make these arrangements. You have made these arrangements through your friends, your family, your work, however it may be. You are bringing that person in because you have to trust them to go into this. Mr. Frazier had to climb a huge mountain for the second time. He understood what this proof was. He understood very clearly what this record looked like the first time, and it was very clear, at least getting up to trial, that he knew that trial counsel was not going to be able to do it.
I understand that Mr. Frazier, from Mr. Frazier's perspective, that the court's decision as to docket management exists
Sure.
on a continuum, and maybe he would make one decision, you and I may make another, someone else may make another decision. In this case, though, where you have 3 weeks to a 9-year-old trial, with the defendant having been out on bail for some time, with the defendant not having communicated to the court that retained counsel was coming in, with retained counsel saying, I cannot meet your deadline, and in fact, it may be as many as 6 months hence from now, that the Sixth Amendment compels the court to continue the trial again?
That's our position, yes, Your
Okay,
Honor.
why is that?
I think that is because the language that the United States Supreme Court has said is we are not, yes, the trial court has to be able to control their docket. That's not what we're saying. We are saying that, in the case being 9 years old, frankly, some of that is not on Mr. Frazier.
No, but it is still the fact, though, right?
That's absolutely true,
And so
yes.
all of the concerns that the trial court would have, that the parties have, Mr. Frazier has, with another continuance, means that that's one more day for witness memories to go away. That's one more day for evidence to be lost. That's one more day for Mr. Frazier, if he wanted to exercise his right to testify, not to remember something tomorrow that he does today. And the court, having its obligation to assure the administration of justice, does have an obligation to assure that a 9-year-old trial gets to trial.
Absolutely.
Irrespective of COVID, irrespective of other reasons why there's delay, though, right? I mean, those issues are real and they're concrete, right?
That's true, yes,
But they
Your Honor.
all yield to the Sixth Amendment in a 9-year-old trial with first notice being provided 3 weeks to go?
That's our position, yes, Your
Okay,
Honor.
sure.
Can I ask you this, Mr. Otto?
Sure.
You mentioned the choice of appointed counsel. I see it looks like Mr. Hedrick had initially been appointed to represent Mr. Frazier. He moved to withdraw in September of 2020. At that point, I believe the trial was set in December, and it was in October that Mr. Rogers was substituted in. Does the record give any indication, A, of any of the circumstances surrounding that switch, and B, whether any of those circumstances played into the trial court's decision later to not continue the trial?
So to the first question, yes, I think that there's a very, I think, one-sentence motion filed by Mr. Hedrick to move to withdraw. At that point, Mr. Hedrick had represented Mr. Frazier, I think, for almost 5 or 6 years. And so I think the court sort of acknowledged that this relationship has probably run its course. Mr. Hedrick obviously got Mr. Frazier a reversal at this court. And so when Mr. Rogers was substituted in, I think interesting with the time frame, the court gave Mr. Rogers about 6 months from when he was appointed on 10/26 of 20 until that April trial date, just for kind of timing on how long it would take to prepare this. But I think the parties in the fall of 2020 said, we're also bringing in a new prosecutor. I think Leslie Nasios was stepping aside, and so they were having to bring in a second chair for now Judge Sanchez, who was the lead counsel on the case. So they didn't really oppose that switch. I think the discussion in April, the trial court is very careful that the trial court does not say, I believe this is a delay tactic. I think everyone sort of dances around it and says, well, Mr. Frazier seems to be dissatisfied again. But I think candidly, Mr. Frazier was in the best position to understand who he had ready to go to trial. The record also contains several pro se motions that are filed by Mr. Frazier. There were no motions filed by trial counsel right before trial. And so when you're talking about boots on the ground, he had the best perception of his case. And so with the time I have left, if the court doesn't have other questions.
I have
Yes, Your Honor.
Okay. So if you're a private attorney and a person comes to you and you find out that they have a case that has been pending for 9 years, criminal case, serious criminal case, you're out on bond, trial's been set, and there's also been a previous trial, so we have transcripts. All of a sudden, and the defendant says, my trial date is this. So do you think the lawyer has an ethical obligation to say, I can't be ready by that date?
Well, and I think that's why Mr. Logan handled it the way he did, was to say to the court, and I think the testimony at the motion for new trial sort of contains that dialogue.
So
We can't.
essentially, the employment was conditional. I mean, the lawyer ethically said, I can't be ready by this particular date.
I think what Mr. Hewitt testified to at the motion for new trial was that we have accepted your money. If we cannot proceed to trial and represent you, we will return your money. Yes, sir. And so on Mr. Frazier's sentencing issue, what I'd like to start with is I know your honors are well aware of all the purposes and principles of sentencing.
So the effect of that was that
Yes.
the defendant knew there was a possibility that his lawyer that he wanted to retain might not be able to represent him because of the fact that the judge might not agree to reset the trial date.
I think that we can assume that, but I don't know that that is actually in the record, Judge.
Okay.
And so when we talk about sentencing, when this offense occurred in 2012, the TCA 4035-210 Section C looked very, very different than it does today. I wish we still had this language, but the language that the trial court did not acknowledge existed was the minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum length of each sentence for felony class to reflect the relative seriousness of each criminal offense for that classification. That language told the trial court you need to start at 15 years for a Class A felony conviction for second-degree murder.
Does it say you need to or
It says
you should?
Should.
On an A?
Yes, on a Class A felony.
15 to 25?
Well, mid-range.
It started at 20 in the old statute, right?
Well, way back.
Okay.
So when the sentencing chart was imposed, I can't remember if it was 2004, but the Class A felony range at that time was 15 to 25 years. And so the trial court does not make any mention of acknowledging that that version of the sentencing statute was what was applicable to Mr. Frazier.
I thought it started at 20. I thought on an A felony on the old statute it started at 20.
I think that was prior to 2012, if I remember correctly. I think when the sentencing chart came out was before Mr. Frazier was charged.
Okay.
But, I mean, we all agree that after the 2005 amendments, though, that these are guidelines the court can take into consideration, but the court is certainly not bound by it. So when you say the trial court must have started at the 15-year minimum for an A felony, I mean, as a matter of law, that might not be fully accurate, right? I mean, the trial court isn't bound to start there. it can consider that.
I think that with the language that was in the statute at the time, the court should have at least acknowledged that the statute is saying that this mandatory minimum sentence has been very strategically picked by the legislature. They have decided that 15 years is a substantial punishment for what these Class A felonies contain, understanding that it contains second-degree murder. And so when Mangrum gives us guidance on applying legal standards, that analysis is nowhere in the record of Mr. Frazier's sentencing. The other enhancement factors that the court found in terms of bringing a gun, there's a very long discussion that we quoted mostly verbatim in our transcripts, in our briefs. The court had decided that because it believed Mr. Frazier brought a gun to this offense, that was one of the largest factors that he applied in imposing the maximum sentence available. And frankly, based on the proof in the record from Ms. Faust, based on the proof from Ms. Biggs, they make very clear in their first and second trial testimony, they did not believe Mr. Frazier had a gun with him when he got into their Jeep to go over to where this fight was occurring. The trial court continues to say, you can disagree with me, Mr. Frazier, you and I will just have to disagree, but until the day I die that you brought a firearm with you. And so the enhancement factor says employed a firearm. The court certainly could have enhanced Mr. Frazier for using a gun in the commission of second-degree murder. The court goes to great lengths to go through a very long discussion about bringing a firearm. That is not part of our sentencing statute. That is not part of our enhancement factors. The other factor that the court relies very heavily on is whether Mr. Frazier was a leader in the commission of this offense. There's no testimony regarding Mr. Frazier's role at all other than being the purported shooter. And so when the transcripts talk about the black crime family and all the folks at this fight being part of this quote-unquote group, there's no witness that actually says Mr. Frazier is a member of this group. He may say it in his interview, but he doesn't. There's no one that makes clear that he is in charge of anybody on this particular day.
Are there other enhancement factors that are present as well?
The only the court on its own decided to consider Mr. Frazier's misdemeanor conviction history. He had 2 misdemeanors. It's not clear in the sentencing transcript how much weight he gives those. The state does not ask that be applied in its notice of intent to seek enhancement. That was something the court found.
But the court could find it. There was evidence from which the court could find it.
Mr. Frazier does have 2 misdemeanor convictions, yes, Your Honor.
So let me ask you this. I mean, is the argument really concerning the weight that the trial court is attributing to enhancement factors? And that Mr. Frazier says, trial court, you should not have weighed those factors in the way that you did?
I think that's the gist of it, yes, Your Honor.
If that's the case, isn't it also true that after the 2005 amendments, that a challenge to the weight of enhancement factors or mitigating factors is no longer a basis for appeal? And so having conceded that the argument is really just one concerning the weight given to enhancement factors, that really this issue is not one that we can take? I want to be clear. I'm not saying that, I think we're saying both of those things. We are saying that some of the enhancements, the way that the court applied them is incorrect in terms of whether he brought a firearm was an incorrect application of the facts to sentencing as well as being a leader. I understand I'm out of time. I can save my remaining comments for rebuttal. Okay, thank you, counsel.
Good morning, Your Honors. Abigail Hornsby for the state. This court should affirm the defendant's second-degree murder conviction. The defendant's various claims are either waived or meritless, and he is not entitled to relief on any of them. I will contain my argument to the issue of the continuance and sentencing as defense counsel did, though I'm happy to answer any questions that this court has about the other issues as well. First, turning to the continuance, the trial court here properly exercised its discretion when it denied the defendant's last-minute request for a continuance. So, to your point, Judge Greenholtz, the right to counsel of choice is qualified. The Sixth Amendment provides the right to adequate and competent counsel, not necessarily to the counsel that you want to have.
Well, that's in the appointed counsel context. I think when the Sixth Amendment says you have the right to counsel and it's retained counsel, I absolutely have the right to counsel of my choice.
Certainly, right? Yes, but it is still qualified. It's not an absolute right as effective counsel is. I think it's more limited by, the administration of justice and the court's ability to regulate its docket and scheduling concerns. And the Tennessee Supreme Court has said that it has to be, the right to counsel of choice has to be balanced against the requirements of the fair and proper administration of justice. And it the court has also said that that right cannot be insisted upon in a manner that will obstruct orderly procedure in courts of justice and deprive those courts of the ability to control how their dockets function and how things are proceeding. So I think in this case, that's really what the trial court was doing here, was it was balancing the defendant's right to counsel of choice against the court's ability to regulate its own docket and the fair administration of justice in this case.
How long had the trial been set?
The trial had been set for around 5 months. It was set for April of 2021. And yes, so for around 5 months, both the state and Mr. Rogers said that they were prepared to go to trial in April. And the court had repeatedly reiterated at essentially every status hearing, every time they came together, that this case has to be tried on that date in April of 2021. It was very adamant. I think it said from the beginning, if you have witness problems, if you have issues with evidence that you need to figure out, like, figure it out, because we are going to trial on that date, period. Like, there's no reason that we are going to reschedule this. It has to be tried. And
So I understand that with witnesses. What I hear your friend on the other side saying, and she'll disabuse me of the notion if I'm saying it incorrectly, is essentially you have a fellow who is out on bail. He's employed. He's trying to get together the funds to hire a lawyer of his choice. He's not particularly happy with appointed counsel for whatever reason, but he's trying to do it. His circumstances are not the circumstances of an affluent defendant, and so he has to have some time to get the money together. And he's asking the court on a 9-year trial that has already been tried once with transcripts of witness testimony, that he be allowed 3 more months so new counsel of his choice can come in. And the Sixth Amendment does not allow that?
in this circumstance, I don't think it requires that, no. And there are two primary reasons for that. So first, the defendant didn't bring up at all that he'd been trying to get the funds together. There was no indication whatsoever until we get to 2 to 3 weeks before trial. And he'd been talking to this firm for at least, I think, close to a month at that point. So that's at least 2 weeks of having conversations with these attorneys he wanted to have represent him, where he didn't tell the court about it. And probably, assuming it took him a while to gather the funds for it, which it sounds like it did, he could have come to the court and said, hey, I'm really trying to find a new attorney. And I think in that instance, we might have a different scenario.
So if he had simply filed a notice with the court that told the court, I am investigating other options for counsel, it's going to take me a little while to do it, then we would have a much different analysis under the Sixth Amendment.
I don't know. I wouldn't say that it would necessarily be a much different analysis, but I think it could be a different case in that scenario. But that's not what we have here. We have a defendant who's been talking to counsel for several weeks, doesn't bring it up to the court, gives no indication that he's dissatisfied with his attorney until right before trial. And the second issue is that the defendant had kind of had a pattern of doing this several months before trial. And some of that had happened before his first trial date, but there were at least 2 occasions where he requested a new attorney because they had only asked for 6 months to prepare for trial. And that was his reasoning, was that he had established that he did not think 6 months was long enough to prepare for trial, and he had requested new attorneys at least twice because they had only asked for 6 months. So there's no reason to think that he would not have done the same thing, certainly if the attorneys had only asked for 3 months.
Maybe Mr. Logan was very efficient. I wonder this, though.
It could be.
I wonder this. No, that's fine. I'm sorry. Go ahead.
And to answer your question from earlier, Judge Hickson, when Mr. Hedrick withdrew, he had been representing the defendant throughout his trial, throughout his appeal, and then the trial was set in December, and the defendant filed a motion, or I think the defendant may have filed pro se motions. I don't recall whether he filed pro se motions on that occasion. But Mr. Hedrick's explanation was that he was no longer satisfied with Mr. Hedrick's representation and he wanted a new lawyer. And the prosecutor very clearly thought that this was a delay tactic and essentially said, look, we all know that Mr. Frazier is trying to delay the trial here, but we're likely going to have a new attorney come on the prosecution side anyway, so we're not going to object in this instance.
So what did the trial court find, though? Because in a lot of these kinds of cases, and I know that my panelists here were former trial judges, and I think did the same thing. In a case where we have a defendant who's routinely requesting new counsel, hearings will be held, inquiries will be made into the cause of the concern, and then findings will be made by the trial court about whether a substitute counsel is appropriate or perhaps not appropriate. And as that happens, time over time, the court's building a record such that when we get to the 3 weeks before trial, the court's able to make a finding that the defendant's just playing games. The defendant's just trying to obstruct the proceeding of the process. And we know the Supreme Court allows that to happen, the trial court to make that finding. But did the trial court make that finding here, that there was an intent to obstruct the administration of justice?
When Mr. Hedrick withdrew, did it make that finding, or?
When the defendant's asking for Mr. Logan to come in.
Yes,
Is
so
the
I
court
think-
making that finding?
I think the court implicitly, it wasn't explicit, it did not make an explicit finding that this is a delay tactic, but the court reiterated several times that it kind of went back to the situation with Mr. Hedrick and said, you had a phenomenal attorney represent you. He did a fantastic job at your trial and on appeal. And then as we got close to trial, you decided you didn't like him anymore. So I think implicit in the court's kind of concern about that and reiterating that repeatedly, it does seem to have an element of thinking that this is a delay and the defendant just trying to get out of going to
Okay,
trial.
that's something we're going to have to infer from the
Yes,
other
it would have to be
statements.
inferred.
Okay, all right.
It is not an explicit, but the court does go back to that multiple times. So it is clearly concerned with, I think, the pattern that as you get closer to trial, then the defendant requests a new attorney. So even though he didn't explicitly say that, he did highlight the pattern of that occurring during all of these
All
proceedings.
right, fair enough. Thank you.
And so again, we have a situation where the case has been scheduled for a long time. The new attorneys aren't able to take the case. The current attorneys are ready to go. And it was also just reasonable for the court to insist on the scheduled trial date. The COVID backlog made things particularly difficult for scheduling. I believe he said that they could only use 2 of their courtrooms, so the 3 criminal court judges had mapped out a trial schedule, which was why he was so concerned about sticking to the schedule, because moving it around would have impacted other cases. There may not have been a time within 3 to 6 months where they could have rescheduled the trial, and there may not have been another case to take its place. So it was reasonable for the court to insist on the scheduled trial date, and it did not abuse its discretion when it balanced the defendant's right against the public's interest in the fair administration of justice here. Turning next to the defendant's sentencing claim, I think, Judge Greenholz, again, you hit it right on the nose that this is primarily looking at the weight and how the trial court weighed these different factors, and that is not a basis for appeal here.
When I pushed your friend on the other side with respect to that, she may have backed up a little bit, and she said, well, I'm not really talking about the weight. I'm talking about the application. And she suggested the trial court misapplied an enhancement factor, or maybe more charitably, applied an enhancement factor that doesn't exist in the statute. She says that the enhancement factor required the employment of a weapon.
Sure. So I think two things. It's possession or employment of a weapon,
Right.
and the trial court highlighted,
Right.
I think, the possession side of that. And also, the defendant has not challenged the criminal history enhancement factor. So the court is permitted to impose the maximum sentence based on one enhancement factor. We have one enhancement factor that the defendant has conceded was appropriately applied. So I think at that point we are simply looking at weight, because the court did not abuse its discretion by imposing the maximum sentence, even if it was solely based on the criminal history enhancement factor.
In fact, you wouldn't need any enhancement factors, right?
Correct.
Even
That
if
is
you
true.
had mitigating factors, as so long as
That
the
is true.
sentence were otherwise complying with the purposes and principles of sentencing.
Yes.
The trial court, and even in that case, could apply the maximum.
Absolutely.
Okay.
But to address the possession and employment of a firearm enhancement factor, to push back a little bit on the counsel's contention that Ms. Faust and Ms. Gibbs did not believe that Mr. Frazier brought a gun, I don't think that's really a fair characterization of the testimony. I think they testified more that they didn't see him have a gun until afterwards, and Ms. Faust said that she asked him because her son was in the car. So there's not really they're not saying, oh, I don't think he had a gun. They're just saying they didn't see him with one. And why would they have seen him with one? Like, most people aren't getting in the car and waving the gun around necessarily. So here, there's not evidence necessarily that he did not have a gun when he went there, or explicit testimony saying that. And the trial court's belief that he had a gun, or its statements about that the defendant has highlighted in his brief, are really pushing back on the defendant's allocution and his attempts to kind of shirk responsibility here. The defendant continually has insisted the entire case that Mr. Melton was the one who brought the gun, and really that the shooting is his fault. And so the trial court was essentially saying, you expect me to believe that while Mr. Melton was being chased by 3 men who were all larger than him and emptying his pockets, backing up the street, trying to say he didn't steal anything, didn't have any money, and then he had a gun that whole time, and then you chased him into the woods, and it's only then that he pulls out the gun. So I think the court is really making it, just kind of a credibility determination of sorts on Mr. Frazier's side of the story, that it's just not believable that Mr. Melton was the one who brought the gun. So I think that's why the court highlights so extensively that Mr. Frazier brought the gun, but really it was applying the enhancement factor based on his possession and employment of the firearm, which is appropriate in this case. And then the leadership enhancement factor, again, that only requires the defendant to be a leader, not necessarily the leader. It doesn't matter if he was the leader of the black crime family. It matters that he was a leader in the commission of an offense. And there are facts here from which you can infer that he and Mr. Ortiz had spoken on the phone sometime before the offense happened. Then Mr. Ortiz and the 2 other men go and find Mr. Melton, and the fight starts. Mr. Frazier then becomes antsy, and he was with Miss Faust and Miss Gibbs at the time, and they testified that he became antsy and wanted to go find Mr. Melton. So it seems that there's at least an inference that he knows something is going on, and he wants to go participate in it and go find Mr. Melton. And then he gets to the fight, yells to Mr. Ortiz, telling him to fight, and then chases Mr. Melton into the woods. And I think from that evidence, there's an inference that they had discussed the fight beforehand, that Mr. Frazier knew what was going on, and he was the one who chased Mr. Melton into the woods and shot him. And that is enough to establish this enhancement factor. And if this court has no additional questions, we ask that you affirm the defendant's convictions and sentence. Thank you.
The one thing that I think is difficult to maybe read unless you read this entire record, which unfortunately I've done multiple times, the trial court makes very clear to Mr. Frazier from the minute he walks back into his courtroom in September of 2019 that he is incredibly frustrated, is the nice way to put it, that his conviction has been overturned and sent back for a new trial. He says repeatedly to Mr. Frazier, you are a lucky man, you should have been convicted of first. And he says at the sentencing hearing, I told you the day the jury returned its verdict after they left that you're a very fortunate man, because if you had been convicted of first, this court would have let that verdict stand and it would have stuck this time, is basically the paraphrase down of what he says. The trial court makes very, very clear from the minute that Mr. Frazier comes back, when he says, look, I have hired an attorney, I would like to substitute with someone I'm comfortable with, to look, I don't think these enhancement factors apply to me. The court has made up its mind. The court said, I saw you walk out of here with a first-degree murder conviction, and now you are back. And I can't give you a first-degree murder conviction, but I will give you a 25-year sentence for this case because that's what I think it deserves. That's not what our principles of sentencing say. That is not what our trial judges are tasked to do. They are tasked with looking at the facts of the case. They're tasked with looking at the enhancements given by the state and brought out by the record. And the cases cited by the state that talk about sentencing, when we're relying just on criminal history, the cases in here, we talk about folks that have decades-long criminal histories. We talk about folks that have been convicted of multiple offenses. We talk about folks that are on DUI, fourth offense, and things of that nature, where we're talking about an 8-year sentence. We're not talking about folks that receive a 25-year sentence for having a misdemeanor simple possession prior to their conviction for murder. When we talk about a right to counsel of choice, the fact that the trial judge insisted that this case, of all the cases on its docket, had to be tried is attributed to the fact that you can look at the record and see the comments that come back when this case comes back from this court. And so for those reasons, we would ask that these convictions be reversed and remanded for a new trial, or at very least a new sentencing hearing.
Mr. Otto, can I ask you before you
Sure.
sit down? If you had to pick one or two cases or precedents that say this choice of counsel is a Sixth Amendment violation versus a valid exercise of the trial court's discretion
Yes.
in sentencing and controlling its docket, what would that precedent be?
I would look at a 1964 case from the United States Supreme Court that we cited, Unger v. Sarafite, S-A-R-A-F-I-T-E, 376 U.S. 575. There's a quote in there that says, "A myopic insistence upon an expeditiousness in the face of a justifiable request for delay can render the right to defend with counsel an empty formality." And so the Supreme Court has said, look, we understand that folks are charged in very difficult circumstances. This was not a situation where Mr. Frazier was playing games. He had simply finally been able to come up with the money to hire a lawyer. Thank you.
Thank you, counsel.
All right. Y'all okay to go to the next one? Madam Clerk, if you'd call the next case then, please.